Good evening. My name is Gilda Medrano, and I will be presenting the case of John R. Harley versus Schuylkill County, 476 U.S. 469, 1979. And this is for course PADM 610, Constitutional Foundations. Plaintiff John Harley brought a civil rights action against defendant Schuylkill County. Defendant filed a motion to dismiss, and the court denied the county's motion to dismiss. The district judge was Judge Hyatt. Starting with the facts. John Harley was employed by the Schuylkill County as a prison guard. On February 28, 1976, when Harley reported to work, he was informed by the acting deputy that defendant Joseph Dooley, at that time acting warden, had left strict orders that inmate Kenneth Hennessy was to stand check in front of his cell, even if he had to be dragged from his cell. Upon examining Hennessy, Harley discovered that the inmate had previously been beaten, and in fact, Hennessy informed Harley that he had been dragged from his cell because he refused to stand check because of his religious beliefs. Harley determined that Hennessy intended to refuse to stand check again and proceeded to secure Hennessy's cell and file a conduct report instead of forcing Hennessy to stand check. Later that evening, Harley informed Dooley of these events and stated that, in his opinion, further physical abuse to Hennessy would be illegal and improper under the circumstances. Dooley stated that he wanted Hennessy to stand check no matter what, and insisted that Hennessy be dragged from his cell. Harley continued to refuse to obey his orders. He felt it was immoral and illegal, and that the orders given were unconstitutional, and that they would deprive Hennessy of his 4th, 8th, and 14th Amendment rights. And that such orders, if carried out, would have subjected Harley to liability for such unconstitutional acts. Harley and the other guards met with the Schuylkill County commissioners to discuss the incident. The meeting ended without resolution. However, the commissioners stated that they would investigate and notify Harley of the results. Later, Harley was informed that he was discharged, but given no reason for his discharge. However, the commissioners' reasons for discharging Harley were widely reported in area newspapers, stating that he was discharged for causing dissension between the warden and the guards and for insubordination. Harley alleges that the reasons given for his discharge were false, that his discharge was wrongful, and that it was a deprivation of his liberty interests without according him due process of law. The consequences. Harley was dismissed from his job without being informed of the reasons. Harley allegedly was unemployed for over a year due to false accusations made by the commissioner. He filed a lawsuit against Schuylkill County for damages, claiming that his dismissal was based upon the refusal to perform an unconstitutional act and the liability of the county for the constitutional torts of its employees. Schuylkill County filed a motion to dismiss the plaintiff's claims. The questions raised in this case: is the right to refuse to perform an unconstitutional act a right, privilege, or immunity secured by the Constitution and law? The answer is yes. However, it is not clearly stated in the Constitution, and I will go further into that later in my presentation. Second question is, does the plaintiff have the right to proceed against Schuylkill County for damages under either the Pennsylvania Constitution or the 14th Amendment of the United States Constitution? And the answer to that is yes. The ruling: the court denied the county's motions to dismiss the employee's civil rights action. The court's ruling for question number 1. Is the right to refuse to perform an unconstitutional act a right, privilege, or immunity secured by the Constitution and laws? According to case Parrish versus Civil Service Commissioners of County of Alameda, this holds that there is a right to refuse to obey an unconstitutional order. However, it's not clear from this case whether this right is secured by the United States Constitution. The court did conclude that the right to refuse to violate another's federal constitutional right is a right secured by the Constitution. And if a plaintiff is under a duty to refrain from performing an act, then the court believes that he has the concurrent right to act. The court believes that the conclusion is supported by strong policy considerations. Parties such as plaintiff, who are acting in the capacity of prison administrators, may daily be faced with situations where they are required to act in a manner which is consonant with the constitutional rights of others who are subject to their authority. And the potential for abuse in these situations can be high. If public administrators are to be encouraged to respect the constitutional rights of others, they must at least have the minimal assurance that their actions are also protected by the Constitution. And for the question number 2, the second question, which states, is the county liable for the constitutional torts of its employees? Plaintiff's complaint states that defendant Schuylkill County is liable directly under the 14th Amendment to the United States Constitution and the Pennsylvania Constitution, Article I, Section 1. The question of whether a direct cause of action may be asserted against the municipality under the 14th Amendment is one which has not yet been determined by the courts of appeals for the circuit. In accordance with the teachings of Gagliari and Petrone, this court need not reach that difficult constitutional issue if there is a pending statute law claim being asserted against the municipality. And here's Article I, Section 1 of the Pennsylvania Constitution, which reads, all men are born equally free and independent and have certain inherent and indefeasible rights, among which are those of enjoying and defending life and liberty, of acquiring, possessing, and protecting property and reputation, and of pursuing their own happiness. Defendant objected that there is no statute which executes the provision of Article I, Section 1, and that the section is not self-executing. In Erdman versus Mitchell, the Pennsylvania Supreme Court specifically held that Article I, Section 1 is self-executing. The court determined that a direct cause of action exists and may be asserted against Schuylkill County. According to Ayala Court's opinion, governmental immunity was abolished with respect to municipal corporations, such as counties and cities. The abolition paved the way for holding municipalities responsible for the constitutional torts of their employees. The court concluded that the county of Schuylkill is liable for acts of its employees which violate Article I, Section 1 of the Pennsylvania Constitution, where those employees are acting within the scope of their official duties. And the additional questions and conclusion, based on the court's decision to deny the motion to dismiss the plaintiff's claim against Schuylkill County, and the county being held responsible for the torts of their employees, should additional training be conducted to ensure abuse of power is eliminated in such situations? And the answer is yes. Based on the readings, administrative law is perceived as crucial to understanding the functions of administrative agencies. This case demonstrates the different perceptions and interpretations of what is considered legal and what crosses the line. However, are there clear procedures to be followed, or is it left for interpretation? Which many times it appears that it is left for interpretation. The book discusses the untidy and frequently unfair procedures followed by many of our administrative agencies in implementing public policies at all governmental levels. Is there sufficient oversight of the implementation of these policies? Many times policies are pushed out and administrators are left to implement. And sometimes these policies may just not be feasible to implement, but they are out there. From the readings, the last phrase caught my eye, caught my attention, which it states, it should not be overlooked that citizens do not really judge public policies as they are written, but by how they are impacted by public policies as implemented by public administrators. Thank you.